So in this video I will be discussing some basic things about criminal procedure. So firstly I will be discussing about cognizable offence and non-cognizable offence. Then secondly we will proceed further to understand that in which cases FIR has to be registered and in which cases FIR need not to be registered. If in the cases where FIR has to be registered, the police is refusing to register the same, then what are the remedies you have to make it register? And then further, what are the other proceedings which will be followed? That we will be discussing in this video. Okay, hi guys. So let's start with cognizable offence and non-cognizable offence. Now you need to understand where to find cognizable and non-cognizable offence. So for that, take your CRPC book. See chapter 1, section 2 is about definitions. Now in definitions you can see that subclause C is about cognizable offence and subclause L is about non-cognizable offence. Now I may read out what is a cognizable offence and what is non-cognizable offence. Now cognizable offence means an offence for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being, enforce arrest without warrant. So a police officer without warrant, if he is taking cognizance of that particular offence, then without warrant he can arrest the person. However, in non-cognizable, which I may read, non-cognizable offence means an offence for which, and non-cognizable case means a case in which a police officer has no authority to arrest without warrant. So in this case, without warrant, the police officer cannot arrest a person. Now first, you need to understand from where you understand that whether an offence is cognizable or non-cognizable. For that, you need to check CRPC. In the last, there is given a schedule, which is first schedule, in which you can see that it is given that whether an offence is cognizable or non-cognizable. On the basis of this, you will understand whether police can arrest you with warrant or without warrant. Now going more detail, why there is without warrant or with warrant. Now cognizable offence, if you check the schedule itself, you can see cognizable offence contains more grievous offences or the offences which is against the state. However, the non-cognizable offence are not that much grievous, or maybe not against the state. So while considering cognizable offence, the police officer will file an FIR and then arrest. However, if it is a non-cognizable offence, the police may not file an FIR. Normally they don't file an FIR, and without the permission of the magistrate, they won't arrest the person. So this is the difference between both of them. Now the second question comes in, that why it is so important to understand which offence is cognizable and which offence is not non-cognizable. So basically, every offence has to be either categorized as cognizable or either get into non-cognizable offence. Why so? Because the FIR is registered by the police only if the offence is cognizable offence. If the offence is non-cognizable, then police won't generally convert it into an FIR, but will take the report and then they will inform to the magistrate. So let's check these provisions which is covered under CRPC, which covers what are the procedures to be followed if the police get the information regarding a cognizable offence and if the police officer gets an information regarding non-cognizable offence. So let's check these provisions which is covered under CRPC, which covers what are the procedures to be followed if the police get the information regarding a cognizable offence and if the police officer gets an information regarding non-cognizable offence. So under chapter 12 of CRPC, chapter named Information to the Police and Their Powers to Investigate, talks about the same. Now section 154 you can see, the heading itself is descriptive. Information in cognizable case. So in such case, what the police officer has to do, that is being given in section 154. So what is 154? Clause 1, subclause 1. Every information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction, and be read over to the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. So basically, the thing which they are saying is that such information has to be recorded in writing, and it may be read over to the person. If the police officer is writing and the informant is giving an oral submission, the police officer has to write it down, and then he have to make it signed by the informant. So this is the basic thing which the police has to follow if the offence is cognizable offence. Now, the subclause 2 says that a copy of the information as recorded under subsection 1 shall be given forthwith free of cost to the informant. So every citizen need to understand that if you are filing an FIR, take a copy of the FIR, because that will be really helpful. That is important too, and you have the right to get the FIR. So this you need to understand. And section 3 says about a situation wherein if the police officer refused to file an FIR, what is your remedy? So in a case wherein you as an informant, or maybe you are the complainant, you are the victim, you are giving an information regarding a non-cognizable offence, but the police is refusing to take that and is not filing an FIR. So what is your remedy? That is given under section 154 subclause 3. So let me read out that. Any person aggrieved by refusal on the part of an officer in charge of a police station to record the information referred in subsection 1 may send the substance of such information in writing and by post to the superintendent of police concerned, who, if satisfied that such information discloses the commission of a cognizable offence, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him in the manner provided by this code, and such officer shall have all the powers of an officer in charge of the police station in relation to that offence. So, if any police officer refuses to file your case, then what you have to do is, you have to take that complaint, you have to make it in a written form, and you have to send it to the superintendent of police or the commissioner of police. Basically, this is what is generally followed. So you can send that through post to the superintendent of police of that particular area, the commissioner of police, and if they find that this offence is a cognizable offence and the police must have filed an FIR, they will take action accordingly. They will either direct the subordinate, or they themselves will do the investigation as prescribed in this code. So that is all about when the FIR will be filed by the police officer, and if they refuse, what is your remedy to proceed against the same. Okay, now let's get into that. If non-cognizable offence has been made, and then you are going to inform that to the police station, then which section covers the same? So section 155 covers the same. Now section 155 says information as to non-cognizable cases and investigation of such cases. Subclause 1 says, when information is given to an officer in charge of a police station of the commission within the limits of such station of a non-cognizable offence, he shall enter or cause to be entered the substance of the information in a book to be kept by such officer in such form as the state government may prescribe in this behalf, and refer the informant to the magistrate. So here, if you remember, in my previous video I said, for the non-cognizable case, without warrant you can't arrest that person. So with warrant you need to arrest that person. Now here the answer to that comes in, like why so? Because Once you get an information regarding a non-cognizable offense, you will record the same and you will inform or refer that information to the magistrate. Now, the magistrate will tell you whether you can get a warrant or not. And the police officer, if he gets a warrant, then only he can arrest that person under a non-cognizable offense. Now, suppose 2 says, no police officer shall investigate a non-cognizable case without the order of magistrate having power to try such case or commit the case for trial. So again, this answers that why so in the non-cognizable case, why the police officer without warrant can't arrest the person. Suppose 3 says, any police officer receiving such order may exercise the same powers in respect of the investigation, except the power of arrest without warrant as an officer in charge of a police station may exercise in a cognizable case. So this says about the power of the police officer. And then where a case relates to 2 or more offences of which at least one is cognizable, the case shall be deemed to be cognizable case, notwithstanding that the other offences are non-cognizable. So this is important. So there is a situation now wherein one offence is cognizable but others are non-cognizable. So if that is so, the police has to follow section 154. They will file an FIR with the non-cognizable offence, and what has to be followed in the section 154 will be followed further during the investigation and the procedure. So this is all about cognizable, non-cognizable, the importance of that, and when the FIR is filed, when not FIR is filed, and what is your remedy when FIR is refused to be filed. I hope you understand this basic things through my video. Thank you so much.